Welcome back to another episode of Twomey Mailbag, where we try our best to answer your legal questions in plain English. My name's Ben.
And I'm Andrea, and today we're going to be answering your questions about bankruptcy.
Just before we get into it, we need to give a quick disclaimer. Nothing that we're talking about here is intended to be legal advice. It's general in nature. Do your own research, get your own lawyers. The names and identities of people in these stories, while they've been inspired by true events, we've anonymised them and made some of them up just to protect people's identities.
Okay, let's get into it.
Let's go.
Let's go.
Bankruptcy session 1. Here we've got a question from someone whose Zen probably isn't the same as it was when they came back from their retreat. I've just returned from a 6-week wellness retreat in Bali and found an old bankruptcy notice in my mailbox. The due date has passed and I'm not sure what happens next or if there's anything I can do to stop it. What can I do?
Okay.
Take a deep breath.
Yes, take a deep breath and... Okay, so the bankruptcy notice has passed. That means you've had the bankruptcy notice in the mailbox for at least 21 days. And after that 21-day period, there's technically what's called an act of bankruptcy. This act of bankruptcy is what triggers a creditor's right to then go and apply to essentially make a person bankrupt. So we're obviously at the point where that bankruptcy notice has expired. And then the question is, what can she do?
Not much.
No. Look, usually, it obviously depends on the circumstances of the person. If they've got money to pay it, they should probably be paying it. But there's other steps that can be taken if there's some reason why that debt is not actually owing, or, for example, there's a reason to suspect that bankruptcy notice wasn't validly served on the person. But those steps are going to have to be taken once the creditor has actually filed what's called a creditor's petition.
So after the bankruptcy notice expires, the creditor files a creditor's petition with the court and the process to actually making you a bankrupt starts.
That's right. So the creditor's petition is essentially a court application. It's going to be filed and that's going to be served on the person. And then they're going to have an opportunity to respond. So that's when they're going to be putting in their material to, say why the debt was never, due and payable, say why they never received the bankruptcy notice, and those type of things.
Right. So in circumstances where he or she has been hit with a bankruptcy notice, the debt which pins to the bankruptcy notice is probably a judgment debt, or it must be a judgment debt.
It must be a judgment debt.
So in those circumstances, what options do they have as far as, let's just say that the debt is, the person's got money. So they've got a vested interest in ensuring that they don't go bankrupt, and the debt is an amount of money that is more than something that they've got in their back pocket. So it justifies a bit of a fight. And it's an amount which they say they're not liable for. Yeah,
so you touched on it before, and that is that behind every bankruptcy notice there has to be a judgment debt. So obviously there's been a court process which has resulted in a judgment. It may be that this person wasn't even aware that judgment had been entered against them. But the key thing there is to actually sort of seek to set aside that judgment if there are grounds to do so. So there's a bit of a process for that. But doing that in tandem with applying for this creditor's petition to be dismissed is something that they can do. They can also, assuming that let's say they do have the money and it's an amount that's, it's not actually worth fighting, they could just pay the amount even though it's after the bankruptcy notice has expired. Wouldn't want to do that if there were other creditors, though, that were sort of seeking to rely upon this act of bankruptcy. But the other option, of course, is before a creditor's petition is filed, that person can go and seek out their own appointment of a bankruptcy trustee. So they can essentially declare themselves bankrupt if that's the option that they want to take. So there's a few things they can do there depending on the situation, like their circumstances.
Yeah. I think the critical lesson is that you sort of can't do nothing and you've got to act really, really quickly.
If you do nothing, you're going to end up with that creditor's petition and within, a few months you'll be bankrupt.
Yeah. I think it's certainly a misconception that people think that well, yeah, there's a judgment against me, but I'm not liable for that amount of money because they got the judgment against me by default when they shouldn't have, or whatever it might be. When it comes to these sorts of proceedings, the court looks at the judgment and that's full and final until it gets set aside. So in a bankruptcy, in a creditor's petition, the court's not going to look at the judgment which underlies the bankruptcy notice. That's something that you've got to do in tandem, as AJ said, with dealing with the creditor's petition. Any other advice other than breathe deeply?
Go on another holiday.
Yeah, go on another holiday.
Yeah. That might help, or it might not.
Good luck. Thanks for your question. Bankruptcy session 2. This question comes from someone who's just applied for a home loan. They were bankrupt 5 years ago, but have been running a successful business since. Well done. The bank said that they won't lend to me because of my past bankruptcy. The question is that legal? I think it's not a question of is it legal, it's more like what are the post-bankruptcy things that you might have to deal with. So did you want to talk about that?
Yeah, so this person's been out of bankruptcy for 5 years. Generally a bankruptcy is going to stay on, or you can search for a bankruptcy on anyone's record for life, but it's not going to be on your credit report after 5 years past the date that you became bankrupt. It could even be sooner. So if that's showing up, if he's applied for a home loan and it's showing up, that's really the liberty of the bank to reject the loan application. As you said, it's not really about whether it's legal or not legal. But I mean, this person might just have to go to a second tier lender or some other institution and just get it across the line until they can potentially refinance.
Yeah, it's probably one of those things that people will come to us and they'll seek advice and they'll say, well, I've got these creditors, I'll just go bankrupt. It's like, well, hang on a second, we need to look at what the knock-on effect of that is, because if you've got, obviously it doesn't give any information here about what the position looked like for them when they went bankrupt, but if they went bankrupt for a relatively, in the scheme of things, smaller amount of money, and it was something that could have been resolved by way of negotiating with creditors or something like that, then the bankruptcy might have been able to be avoided. And in those circumstances, this issue wouldn't have arisen. Of course, there's also other circumstances where there's nothing you can do about the bankruptcy. There's nothing you can come up with, and it's just gonna happen. So I don't think there's any other advice to offer him other than the banks are at liberty to do what they are, to lend to whomever they please or not please. And yeah, it just might be that it's finding funds from a second or third tier lender until you get yourself in a position where you can refinance it under a better rate with a first tier bank. Anything else?
No, I think that's the right point, is that you really need to think about these things before you're going into a bankruptcy scenario, because there are other options that might be better.
Both formal and informal. Thanks very much for your question.
Okay, bankruptcy session 3. We've got a question from a sole trader running a roofing company with 5 employees. The person's fallen behind on their taxes, and the person's accountant says that they owe over $100,000 for BAS, PAYG and super. There's no other creditors, and the person wants to know, how can I restructure my business to manage and pay off this tax debt? Over to you, Ben.
Potentially more complex than it might otherwise have been if you weren't a sole trader trading through your own name. So I think given that bankruptcy is the theme here, we have to assume that this person is an individual sole trader rather than operating through a company. I think it's probably worth addressing the issues with that. Obviously, if you're trading in your own name and you're employing people in your own name and you're doing jobs and whatever it might be in that name, you're the entity against whom they've got these claims. So it isn't the same as if they would have a claim against the company, and then you might have some different options available to you as far as restructuring things. There's obviously the small business restructure and that sort of thing, which isn't available to you as an individual. So that's probably something that it's not necessarily too late to look at it in the future, and restructuring your business to trade in that way moving forward. It's not going to help you with the debt that you've got. I think the thing that you're probably going to look at is, I mean, it says that they've got no other creditors. It's looking at what's your ability to actually pay this debt.
Yeah.
I mean, if the business, if there is a reason why these bills weren't able to be paid, why the BAS wasn't able to be paid in the PAYG and the super, and the business is able to trade out of it, then it might be that's the path forward, to either get external funding or to come to some sort of an arrangement with the ATO to enter into some sort of a payment plan to pay it off over time. It's going to come down to what your ability to pay that off is. I mean, with 5 employees and 100 grand in, we've obviously got to know what proportion of the 100 grand is BAS, PAYG and super, but if the ATO is going to accept the payment plan, then they're going to want to be comfortable that you've actually got the ability to meet it. The other option is obviously getting external funding. Can be difficult to get funding when you've got tax debts, not impossible. It's just about whether or not your business is in a position to be able to get that funding, and then also whether it's worth it. So,
yeah, what I was thinking is that, I mean, this person might not have the ability to repay that amount, but the cash, like the business itself, is viable. So if there is, or there does need to be a bankruptcy scenario, it's actually not going to prevent that person from continuing to trade as a sole trader while bankrupt. But to your point earlier, you might actually use that opportunity to restructure and, restart this business through a company. It's got to be done legitimately, obviously. You can't sort of have a business that is just transferred over to a company and, it magically has lost all of its debts. That still needs to be managed. But, I mean, bankruptcy is not the end of the world in this scenario. So that is definitely an option still.
Yeah. As well as a personal insolvency agreement.
Yep.
Again, it's going to come down to if the ATO is the only creditor, then it's going to come down to what they'll accept.
Yeah, the ATO have their own rules about what they will and won't accept by way of debt arrangement. So there could be something specific there to look at as well, in terms of an arrangement with the ATO as opposed to a personal insolvency agreement, which you might do if you've got more than one creditor. So he's not in a too bad position, but there is and there's some options, so that's good.
I think if there is the ability to come to an arrangement with the ATO, you'd probably do that provided that everything's above board, as you said, of course, with moving the environment within which business is engaged into the corporate world. So is operating through a company. How doable that is going to depend upon the value of the business. It could be worth not much, but if, for example, it's got one big contract and the contract goes for years and years and years, then obviously that's the other end of the spectrum. So certainly some things to work with. It's probably all just going to come down to your ability to service that debt, to ultimately pay it off. If you can, then you've probably got a good chance of working something out with the ATO, I would have thought.
Yep. Bankruptcy session 4. We have a question from Jennifer. Jennifer says, I lent my friend $20,000, but they said that they can't pay me back and plan to declare bankruptcy. How do I know if they actually do? What?
Declare bankruptcy.
How do I know if they actually do declare bankruptcy? And how do they even do that? Also, what happens to my money if they go bankrupt?
I'll start at the end. What happens to my money if they go bankrupt? Usually you don't see it. So in certain instances where someone is bankrupted, the bankruptcy trustee goes in to control their affairs, they realise assets and they pay a dividend to creditors. If you're the only creditor of your friend for 20 grand and they're choosing to go bankrupt instead of paying you the 20 grand, then based on our experience, the likelihood of you getting a dividend is very, 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 very small, or smaller than that. So you probably don't get your money.
Yeah, I think Jennifer's also concerned that someone's threatening to go bankrupt to get out of paying a debt. But how does she actually know they're going to do that?
Yeah.
Are they just going to rock up at her house and say, oh, I'm bankrupt, I don't owe you anything? Is that how it works?
I don't know.
No, so let me answer my own question, or Jennifer's
Of course
question.
I know.
Of course we know. Okay, so Jennifer's friend, how do you know if they're going to go bankrupt? You can always do a search. It's called an MPII search. It's going to reveal if anyone's been declared bankrupt. Lawyers can perform that search, so that's a very simple way to figure that out. And if you do figure that out, what you really need to do is be in contact with the person, the trustee that they've appointed to manage their affairs, and let that person know that you're a creditor, how much you're owed, and then you sort of go into this administration process, and you might find out some months later down the track that there's no assets to be just collected and dividends to be declared.
Or you might get lucky and they might have had a timely inheritance, for example.
Yeah, and if you do,
they can go in there.
Yeah, that would be nice. If, for example, you've done this search, or this person has maybe even said, I have just declared bankrupt, and you do a search and find out that that's not true. Yeah. There are obviously steps that should be taken at that point to start recovery action. Yeah. So
I think the critical aspect with any debt matter is to understand the means of the person that you've got the claim against. So if this person is saying, I'm just going to go bankrupt, I'll go and do it tomorrow, and you do some searches for property or whatever else it might be, and it's just a bit sus as to whether or not they would actually go bankrupt for 20 grand, and you can see what appears to be other assets that they've got, whether it might be, if they had a very expensive car, they might have it on finance anyway, but they might own property. That's the most obvious one. If someone is saying, I can't pay you back, I'm going to go bankrupt, but they own their home, then that's probably a reason to doubt what they're telling you, and then to look at what your other options are as far as getting the money out of them. For that sum of money as well, if they're fobbing you off, and it sounds like they are from the 2.5 lines of question that we've got, it certainly sounds like they're fobbing you off. It could be that putting a bit of pressure on them and seeing if they're serious about going bankrupt actually yields something for you. On the other hand, if you think they're serious and they've got no ability to pay you, if they go bankrupt, high risk you get nothing. So it might be worth rather trying to come to some sort of an arrangement with them to get you some money over a period of time, because that's going to be better than nothing, maybe, unless you want to make them bankrupt. That's up to you. You're the creditor. But it could be that they pay you off over 2 years, for example.
Yeah, and I think herein lies the problem with loaning money to friends, is that this person, might be your friend one day, and when push comes to shove, that person is going to lean on the friendship and, try and come out with all sorts of reasons why they won't pay you. So even if you're, doing things for friends like that, it still needs to be documented. You want to look at this from an arm's length. What can you do to protect yourself in the event that this friendship is not going to last? So next time for Jennifer to do that.
Thanks for your question, Jennifer. Bankruptcy session 5. Here we've got a question from someone that says, I own my own home and have a mortgage. I've fallen behind in my repayments, so I set up a payment plan with the bank. I've been struggling to meet the repayments and I've just received a default letter from the bank. What will the bank do next if I can't get on top of it? So I think we're assuming, for the purpose of the question, we're assuming that no one's sued anybody yet.
Yeah,
the bank hasn't
it's
sort of
pretty.
recovered
Seems like
possession
it's
yet.
Pretty early days, but essentially, the bank is just a lender, but they're bound by codes of conduct, and they've got obligations. So they're going to have to start by sending up those following things, but before they actually take any action, they've got to send some more formal notices. So there are going to be a few rounds of notices before there's going to be any, serious outcome, such as, repossession of your home. But what you'd be looking for is something you might get, which is called a notice of exercise of power of sale. That's a pretty critical notice. And if you get that, that's when you really are getting to the pointy end of that process. But banks, as I said, have got these obligations, so you are better off getting on the front foot, getting in contact with the bank, telling them that you're in financial hardship, trying to work out some sort of arrangement.
What you plan to get out of it is they're going to be very interested in that. If it's selling it, then communicating with them about that so that they can leave you alone so that you can go and sell it rather than them, if they exercise power of sale or they put a receiver in or whatever, then there's going to be a whole lot of extra money coming out of whatever equity there might be in the property. So
yeah, we've certainly had situations where people have gone, they're through the process and the bank's sort of, getting ready to exercise their power of sale, and we've been able to say to the bank, the property's already listed for sale. We're, doing X, Y, Z to make sure it sells, at market value. You're going to get paid in what we anticipate to be this period of time. And, usually the banks are pretty, content with that as long as they can see that these steps are all reasonable and it's not going to hurry up the process, if they do it themselves. So you just have to show that you're serious and you're not sort of trying to fob them off.
Yeah, 100%. If you're looking at the question, what will the bank do next if I can't get on top of it? It's more so what will the bank do next if you don't communicate with them. If you don't communicate with the bank, then in our experience anyway, they're going to take the approach that you're not going to communicate with them, and they've got to do whatever they need to protect their money, and their money is secured by your property, and that usually means selling the property. So communicating with them is always the best bet.
Yeah, and I think as well, just on that point, is that this, mortgage might be cross-collateralised. There could be other assets out there that you just don't really contemplate are at risk. So, think about those things and try and get on the front foot.
Yeah, things that you control are always going to be, there's always going to be a better outcome rather than letting the bank go in and do what they, not necessarily do what they please. It's just if the bank steps in and takes action, there's more cost to be incurred. And as I said earlier, that comes out of your equity in the property, if there is any, and obviously you want to preserve that for yourself. Given that this is a bankruptcy session, if using round numbers, you owe $1 million on the property and it's worth 700, and the bank seizes it and sells it, the bank will recover what's realised from the sale of the property after obviously payment of expenses associated with the sale. But then that amount that's left, you would still be on the hook for that. So the option of a bankruptcy might come into it there.
Yeah.
That sort of involves an analysis of all your circumstances and whether or not becoming a bankrupt would affect your ability to hold licences, or, for example, if you're a builder, or various other things as well. So
yeah.
Thanks for your questions and good luck. That's it for another episode. Thanks for tuning in. Don't forget to follow and subscribe. And submit any questions that you've got either in the comments below or send us an email. We'll put that in the link as well. Thanks for watching and look forward to seeing you next time.